You have to be personally served with it. The rules are that they will personally serve you with it or try to personally serve you with it. If you're not there, they'll post it on the door. They'll come back. I think it's like maybe at least 24, maybe 48 hours later at a different time of day, separated by a certain amount of hours. They will go and try to serve you again. If you're not there, they'll post it on the door a second time, and then they'll get $5 from the landlord, and they will mail it to you. Service will count. Once they mail it, service will count, I believe, after 10 days. And so that means 10 days from the mailing date, you're counted as being served, and then you have that 10 days from there to request a hearing. Keep in mind that if it is posted on the door and you call into the court, that is you acknowledging that you've received it, and that counts as service on that day you're calling to the court. Okay, so basically just a little bit about South Carolina Legal Services. You know, what I can do here, let's see. And this is going to be I think a little more important, is when you get served, because this kind of applies whether you're in subsidized housing or not in subsidized housing. It's the same either way for this part of it. We talked about what happens when you get served. You can call South Carolina Legal Services, you can ask for assistance, but keep in mind, if we don't immediately respond to you or there's a deadline the next day, just because you've called us, that deadline doesn't stop. So you need to make sure you're meeting those deadlines for requesting that court hearing if you're not sure you're within that 10 days. As we talked about 10 days, if you don't, they're going to assume that you are acknowledging that whatever they're saying is accurate, and that admit it's kind of what they would call default, and essentially admitting that they can evict you. If you contact the court, then they should schedule a hearing. They would schedule a hearing in front of a judge. Be aware that there's a lot of magistrate courts out there. There are a lot. In every county, there are a lot. And there's various magistrates even within the county. And some courts, even within the same, might be in the same county, might still do things a slight bit different. I've heard some magistrate courts will require people to come in person and request the hearing. Some will ask them to fill out a little short answer form or something like that. So just be aware and try to be aware with what the court is requiring of you to get the hearing. I'm not saying whether it's right to make people come in person or not or whatnot, but it's a lot easier to get that hearing as best you can than trying to figure it out down the road after there's been a writ of ejectment or something, and trying to unwind things and pull things back. So it's a really important thing to not miss that. And a lot of people sometimes will miss that. Don't think just because you've talked to the landlord or the property manager that they're just going to tell the court or something like that. That doesn't count. Just talking to the property manager, you've got to request that hearing from the court. Okay? If you want a jury trial, you have to do that in writing, and you have to do that at least 5 business days before the date of the trial. That should mean that the court should be scheduling you a hearing at least more than 5 business days from when you request it. That may not always happen. If they schedule you one too fast or something like that and you want a jury trial, I would say put it in writing, tell them you want a jury trial, and move forward with it from there.